from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to part 3 of our series entitled The People's Law School. In this 6-week series, we're dealing with various areas of law, and we try to meet the needs of our viewers, whatever state you're in, although some of the specifics will be about Idaho. On this program, we're going to talk about criminal law, and we're very fortunate to have 2 gentlemen who are highly qualified to address this particular topic. I first of all welcome to our program from Kootenai County, Idaho, the prosecutor of this county, Bill Douglas, who is completing his 2nd term in office, and he will be discussing it from the perspective of the state or the prosecution. Bill, welcome to the program.
Well, Tony, thank you.
And I'm equally pleased to have here Ron Coulter, who is also from Kootenai County, Idaho, and he is the public defender for this county, and he shall approach our discussion today from the viewpoint of the defender. And Ron, it's a pleasure to have you on our program.
It's good to be here, Tony.
And as always, I'm very pleased to have our 2 regular panelists to join in the questioning about this very important topic. First of all is Janelle Burke, who is an attorney in the state of Idaho and also a law clerk for one of the district judges in the 1st Judicial District. And next to her is Steve Schenck, who is the Dean of College Relations and Development at North Idaho College. And I shall ask Janelle to commence today's questioning.
It's very good to have you here today. In order to set the tone for our program, I would like to ask you in general about your offices. The criminal law is an area that's getting a great deal of attention from the media. And so it would be helpful, I think, for our viewers to understand what exactly is a prosecutor, what is a public defender. And let's start with you, Bill. What is a prosecutor?
Well, Janelle, basically the role of the prosecutor in the American justice system is to protect the public, and also in protecting the public, the prosecutor's role is to also achieve justice. We do that by prosecuting crime, felony crime, misdemeanor crime. We also represent the interests of crime victims, which is a very important role of any county prosecuting attorney or any state's attorney or attorney general, however that person is classified. Another role that we have is to represent the interests of law enforcement and to ensure that law enforcement and the other operatives of law enforcement basically perform their missions in detecting crime, in arresting defendants, and in presenting the cases to us within the framework of the Constitution and the Bill of Rights. That is, we ensure that the detection of criminals and apprehension is done with all the constitutional protections that are afforded every free citizen in our country. Our job is then to take those cases, present those cases to a jury of the defendant's peers, and basically achieve justice, engage in that search of the truth, which is what we know as a jury trial. So basically that's our job, is to protect the community, to represent crime victims and law enforcement, and to do so with a sense of justice.
So you're the state's attorney, and most every jurisdiction has a state's attorney.
That's
It may
right.
be known by different names, but most every state has
That's
such
right.
a
Here-
person.
Here in the state of Idaho, the county prosecutor is an elected representative, as the elected prosecutor is in a lot of other states. However, in a couple of states, that's not the situation. I believe in Alaska, the local prosecutor is actually an appointee of the Attorney General. And there's at least one other state, I can't think of which one, on the eastern seaboard, where the local prosecutor at the local jurisdictional level is an appointee of the Attorney General. But basically, prosecutors come in every term. You call them DAs, you call them assistant U.S. attorneys, you call them city prosecutors. But basically, as the county prosecutor, we also work hand in hand with city prosecutors who have jurisdiction to prosecute those crimes which occur within a city municipality, whether that be Coeur d'Alene or Post Falls or Ratram.
And Ron, what about the public defender? What is a public defender, and how do they get their jobs?
Well, basically the public defender in Kootenai County gets this job basically from statute, and we're basically appointed after a search is done, and we are appointed basically by the Board of Commissioners. Now that's the public defender himself. We have deputy public defenders, and those deputy public defenders work for the public defender who's been appointed. And their job basically is to, in our area, is to take care of the indigent defendant, someone who can't afford an attorney, and then we take care of them.
There was a famous case from which public defense almost grew. Can you tell our viewers a bit about that?
Well, basically, it was the case of Gideon versus Wainwright. I mean, there were some other cases before that, but basically, Gideon versus Wainwright says that in any place where you have a critical point in a criminal procedure, then you would rate a defense attorney, and that's basically. I mean, we can go through a whole lot of stuff, but that's basically the call there. So what that does mean is that you get public defenders, and now they can either be contracted out or they can be appointed, but that's basically how it all works.
So a person is entitled to be represented by counsel. That person can be either private or public, and in your case, you're a public defender, meaning that you are a defender for the indigent. And I would assume that in most jurisdictions there's some kind of a level at which a person is declared to be indigent and entitled to the public defender services.
That's correct. And basically, we don't decide. I think that's kind of a good point to bring up. The judiciary decides who gets appointed a public defender. Basically the person, or who we could call later the affiant, stands up and says, okay, these are my assets, etc. The judge basically takes a look at that and says, okay, you rate a public defender, and then we go out and we represent them. We don't troll for business, that's for sure, and we definitely got enough of it. So and we don't question the appointment. We just do our job.
Steve Sheen.
Bill, I wonder if you could take a minute and just take us through the process. I've got some legal experts here, but I think maybe most of the audience, like me, are not legal experts. What happens between arrest and conviction and sentencing? What are the basic steps that take place?
Sure. Good question, Steve. There's a couple ways which a criminal case can start, and I'll just use a felony case as an example. An arrest is made of a defendant or a suspect. He's not a defendant yet, he's only a suspect. Becomes a defendant when the trial starts. That arrest can be made either without a warrant with probable cause, or with an arrest warrant, also upon a showing of probable cause. Probable cause is basically the standard by which the entire criminal justice system is hinged. Law enforcement officers have to have probable cause that a crime was committed in order to effect an arrest, and that a person committed that crime. The second stage is once a person is arrested, every criminal defendant in this country, or criminal suspect, I should say, in this country, under the Eighth Amendment is entitled to bail. Person may or may not post bail. That person is also entitled to a first appearance. Here, it's within 24 hours or without delay before the nearest available magistrate. If it's on a weekend, then basically that person must be brought within a magistrate within 48 hours. At the first appearance, the charges are basically explained to the defendant's desires as to whether he has his own attorney or whether he's going to be represented by the public defender or Ron's office is explained to him. An arraignment or a preliminary hearing date would then be set. For defendants in custody, we must bring, or the court system must bring, a suspect to a preliminary hearing within 14 days if a person's in custody. That's the next critical stage here. That person then, the suspect, becomes a defendant before a preliminary hearing. 21 days is the time requirement to bring someone before a preliminary hearing if he or she is not in custody. At that time, basically we have an adversarial proceeding. There's a prosecutor there, there's a magistrate judge, there's a defense lawyer there, and a defendant. At that time, the state or prosecutor puts on just enough evidence to show what's called probable cause. Again, we hear that term probable cause into our vocabulary. At which time, if the state meets its burden of probable cause, we go to the next stage, and that's called an arraignment. If we can't meet our burden, then basically the charges are dismissed and the state has the option of doing it all over again. Arraignment is then when the stage at which the lower court, the magistrate court, releases its jurisdiction to the higher court or district courts here in Idaho. In Washington, they're called superior courts. At the arraignment, the defendant then enters a plea of either guilty or not guilty. If a not guilty plea, then the case is set for trial. In Idaho, that has to be done within 6 months from the time of the entry of a defendant's plea. Next critical stage, of course, is the jury trial, unless the defendant waives his right to a jury trial. Assuming there's a conviction, a unanimous verdict of 12 people, then there's an appeal, a right to an appeal within 42 days. Then the first avenue of appeal would be to the Idaho Court of Appeals. And then if the case is affirmed, then a defendant can then petition for review to the Idaho Supreme Court. And theoretically all the way up to the U.S. Supreme Court. And I just want to interject that at the preliminary hearing stage, a case can also be started before the grand jury, which is provided for by the Idaho Constitution. So,
one more question to Bill, and then I'll go over to Ron. We get all these terms confused, we lay persons. You said that after a person's arrested, usually within 24 hours or 48 hours, the first appearance before the courts. And at that time, what the defendant has an opportunity to try to make bail or...
That's right. That's the first time at which a magistrate judge would set bail on a felony. If it's a misdemeanor arrest, you know, usually an officer writes a ticket, say, for driving under the influence or for a petty theft, then the court has a bond schedule, $500, for instance, for driving under the influence. That person can automatically routinely post bond by whatever that bond schedule provides for a misdemeanor.
And then you're indicating we go the step of the preliminary hearing, and as that is indicated in some states you have a grand jury indictment. Some states, like this state, the prosecutor can issue information, which is the indictment that takes the place of the grand jury indictment. Is that correct?
Basically, under the preliminary hearing track, which is the way we do most of our cases here in Kootenai County, assuming there's enough probable cause presented by the prosecutor, then the prosecutor then has 14 days to charge or draft a criminal information.
So what you're really doing to the court and the judge, you are convincing the court that you have enough evidence to continue on, or otherwise the case would be dismissed.
That's right. And the case can also go on the grand jury track, which is something new here in Kootenai County, but it is provided by court rule and by Constitution. And we could start at that stage as well.
And once you've satisfied the court that you have sufficient evidence and you've passed the preliminary hearing, then you indicate you have up to 6 months to get to trial with the case, right?
That's right. From the entry of a defendant's plea of not guilty, which is usually at the arraignment stage.
Now you're distinguishing between the preliminary hearing and the arrangement stage, or is it the same?
Well, basically, it's the preliminary hearing. It precedes the arraignment by about 2 weeks.
Okay.
But actually, the 6-month speedy trial rule applies from the date the defendant is in custody or the entry of plea, whichever comes first. So 6 months from that time.
So at the arraignment, you're getting the final step in process before trial.
That's correct. That's correct. The arraignment, of course, then the district judge or the court of general trial jurisdiction basically explains the defendant his rights, sets various orders for the parties to make pretrial motions. Let's say there's a questionable search or a search issue as to how evidence was gathered by law enforcement. The judge then sets the time for which defense counsel shall make motions, and by rule that's within 14 days after the arraignment. It can be extended, of course, by stipulation by the judge. So.
Ron, we'll turn to you. You're on the other side of this question when the defendant is facing all of these situations, the preliminary hearing and the arraignment and getting ready to go to trial. You too have some choices and alternatives, do you not? Give us some idea of the kind of things you watch in that process as the prosecutor is proceeding. And share with the viewers, actually somewhere along the way, sometimes they don't even reach trial, do they?
Well, sometimes it doesn't reach trial, but and that's basically part of the process too. You know, when you by the time you get to trial, everything else is basically falling out. And there's some things that you're going to take to trial because of the nature of the offense. But quite frankly, as you move along, if we went to trial on all of our cases, there just wouldn't be enough judges, there wouldn't be enough attorneys. The system would break. What we watch basically is the Fourth and Fifth Amendment. I mean, that's the one that we really key in on, because as you can figure out, we're at the receiving end of everything. The prosecution has had its investigators, they brought the case, etc. And so at that particular point, we start focusing on the client, and we start focusing on whether or not there was any Fourth Amendment violation, and by that I mean the illegal search and seizure, whether or not the Miranda rights were basically violated and that type of thing, the right against self-incrimination. So we basically look at it that way. We're always on the lookout, quite frankly, to see if, in fact, the government has met its burden and done everything correctly. I think that's the best way of looking at it. And then once you do that, it's to whether or not the government has met its case, and that's the point. And if we get to a point where we can't resolve it, well, then we have a trial, and then we let the people resolve whether or not the guilt or innocence of the individual, or quite frankly, it's not whether or not it's the guilt of innocence of people when they render that verdict, it's whether the government or the state has proved their case beyond a reasonable doubt, which is certainly something rather than different than guilt or innocence.
We often hear criticism of plea bargaining, but you really have said something important. If there were no plea bargains at all, the taxpayers have no idea of how much more it would cost to take everything through the courts.
Their taxes would be going to the court system. The plea bargain is something that has to be done. It just has to be done.
Janelle Burke.
Well, along the line with that, I'll turn to Bill first and say, how do you decide when you're going to take a case to trial in this bargaining process? And I take it that there are some economic considerations here. There are some considerations as to how good the case is. And can you enlighten our viewers as to why are some cases taken all the way to trial and other cases not?
Janelle, on the issue of plea bargains or plea negotiations or plea agreements, I just basically want to say that in this state, certainly this county, and like in most jurisdictions in our country, we don't have enough courtrooms, we don't have enough judges, we don't have enough prosecutors or public defenders to take every single case to trial. It would just be simply too overwhelming and too expensive. We have to weigh the most serious crimes, of course, we classify as crimes against persons. Crimes by repeat offenders, those who have had a bite at the apple. We have to look at those cases very, very closely as to whether we want to initiate a plea agreement. And we do initiate plea agreements with Ron's office all the time. We have to look at drug cases. We try to separate the drug cases. Is this a possession case, a mere possession case, or is this a delivery or trafficking or conspiracy to deliver case? We have to weigh the strength of our evidence. We have to weigh any motions which Ron's office has made. Perhaps Ron's office has identified some real good Fourth and Fifth Amendment issues where a person's reasonable expectation of privacy has been invaded. We have to weigh all these things. And when there's a question as to the strength of the evidence, do we want to roll the dice before 12 people, take the risks and the taxpayers' time and expense and risk an acquittal? Or do we want to achieve the same result? Let's say dismiss a count, enter into a plea negotiation on sentencing, and achieve the same result, ensure the defendant's guilt, ensure the defendant's incarceration, and basically negate the chances of a successful appeal. So all these things are balanced in the equation. You know, we sort of have a saying in our office that we're not going to enter into a plea bargain unless it's a plea bargain for the people. You know, and the people, basically, number one, the crime victim. Crime victim always has a part in the negotiation process. What do you think about this offer? Will this meet your needs? Will you feel protected? And law enforcement, we try to bring them into the mix. Of course, it's ultimately our call And so it's a very, I think it's a necessary part of the process. We just don't have the resources to try every case. So.
And Ron, what about the comment that people often make? How can a public defender defend someone that they, when they suspect or maybe even know that they might be guilty? What is your answer to that kind of a comment?
Well, first of all, we don't know anything. All we know is that the state has filed a criminal complaint, or they snuck by us with the grand jury, and all of a sudden we've got this individual here in front of us. The bottom line in American jurisprudence is this, and especially in criminal law, is can the state prove their case beyond a reasonable doubt? So therefore, we don't question whether or not a person is innocent or guilty, because that's not our job. Our job is to provide the defense, the best defense possible for the individual. And quite frankly, when we hire people in our office, I know, at least I do, and I'm sure most public defenders do, you have to ask them, can you represent an individual who's been accused of child molestation? Can you represent an individual who's been accused of rape or some of these other things? And the answer had better be yes. And we go through a few other, basically I call psychological checks as far as I can do, and before we hire someone, because that's what you do. And I've been on both sides of the fence as far as being a prosecutor and a defense counsel, so it's very easy for me to make that intellectual distinction that you have to have as a public defender, or any defense counsel, whether he's a public defender or in the private sector.
Steve Sheen.
Setting aside for a second the fact that neither one of you has the resources that you'd like to have, in terms of the process and the law, do you feel you have the tools you need to do your jobs properly?
Well,
okay, I'll take that one.
Okay.
I'll take
Okay.
that first.
Okay.
Well, quite frankly, in Kootenai County, I think one of the reasons that I got hired out here was to bring a little organization to the public defender's office and to address the needs of the public defender's office. I have been working pretty closely with the commissioners in regards to identifying our needs and that type of thing. I believe that after this budget cycle that we will probably be a lot better off. It's like anything else. We're shooting for the optimum, and that's what we're going for. And I think that the county is responsible towards that, and I think that our office is responsible towards that. And it's my job as a public defender to say, hey, we are below this level, or we're not at this level. And remember, we're talking about the constitutional right of the indigent defendant. This is not up to taxpayers' money. This is, as a lawyer, are you providing the best service to the client that you possibly can, as mandated under the Constitution? And I have to make sure that our budget and our manpower meets that level, so that I can, in fact, meet the requirements of the Constitution. And that's what I look at, the Constitution. And remember, as a public defender, I am not concerned about how much it's costing me to defend Joe Schmo. He could be the poorest person in the world with no chance of doing anything. My job is to defend him and do the best job I can, and we don't stop at anything to do that. In regards to plea bargaining, I just want to comment on one of those things. We don't, as public defenders, plea bargains are certainly great for our clients, but it's always up to the client to accept a plea, and it is always their right to go to trial. So you see sometimes it works, and the reason why we have so many plea agreements is because the client says, this is a good idea. Okay? I just wanted to make sure I cleared up that point.
Your thoughts, Bill?
Yep. I think, I'll tell you, if you really want to know what's going on in the criminal justice system on a daily basis, visit my office or visit Ron's office. I can tell you, both our offices are terribly, terribly strapped. Mm-hmm. On resources, our main resources is our people, and we look for people. I think we have a very good staff who's committed to justice. We try to, we're the creatures of budget. We do make decisions based on budget, on cost, and we have to weigh that into the equation. I would hate for this county ever to reach a point where the prosecutor has to start eliminating certain types of prosecution. I don't think that's fair to crime victims. I don't think that's fair to this community or to law enforcement. We do the best with what we have. At some point there reaches a point where very committed deputy prosecuting attorneys, deputy public defenders reach a saturation point. There reaches a point where you can no longer adequately represent the young victim of child molestation, or the adult victim of sexual assault, or the victim of domestic violence, simply because you're scrambling to basically to cover court. So, Steve, we have a very, very strapped system. I don't think we're unique. The latest court statistic showed more than 50% increase in our felony court filings. And I can tell you, as the juvenile prosecutor as well, we see a comparable increase in that, as well as dealing with the matters involving our most vulnerable citizens. That is, those who are mentally incompetent. We're responsible for those as well. We've seen an increase there too. But it's a challenge. It's a daily challenge. None of our folks took their jobs and responsibilities and took the oath of office to be deputy prosecutors to get rich. You know, I think we're here because we're committed to justice to this community.
We have 2 minutes left, according to the signal, and I want to get one final question in. We've had a lot of high-profile cases. The O.J. Simpson case is just an example. And now that's come a debate on the courts and reform and television, the courts, and so forth. Ron, I'll start with you in about 30 seconds, 40 seconds. Do you have any recommendations of any changes, or is the system working as it is?
I think there's no room for television in courts. I mean, you want an honest opinion, I'm going to give you one. I just don't think, I don't think that serves any purpose whatsoever. I was in San Diego County, which is right south of L.A. County. It was certainly something high profile. Being a minority, I certainly had an interest in what was going on in that particular case and everything that was surrounding it. Having gone to junior college, OJ went to too, and knowing his coach, you know, certainly was something I was looking at. But you need to keep the media circus out of the court system, and I guess for the media, when you do report on a court system, make sure you report right and get with someone who knows what's going on rather than just putting something out there. Bill, what reforms or any would you recommend?
Well, on cameras in the court, I think the jury's still out here in Idaho. You know, we're still within our 12-month window, our experimentation basis. I think if properly monitored by a good, aggressive trial judge, you know, I think that's doable. But I'm sort of in agreement with Ron, and I have my skepticism. But I think here in Idaho, the jury's still out.
We're going to have to interrupt. I do assume that you both still support the jury system as a good way of dealing with the courts.
Absolutely.
Ladies and gentlemen, we have had two very informed guests today, the Kootenai County prosecutor and the Kootenai County public defender dealing with criminal law, and I invite you to be with us next week when we'll do part 4 of this series on the People's Law School. I hope you're finding this most informative to you, and until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.